Hello everybody, welcome to iExamB. Embrace the iExamB learning experience. In this video, we are going to continue with our discussion of previous year questions that have come in Coal India Management 20 legal exam, and we will be discussing questions from topic Indian Contract Act and Specific Relief Act. I have already discussed this table with you. From Indian Contract Act, there has been 10 and 8 questions in the past two recruitments, and from Specific Relief Act, there has been 2 and 5 questions. So good weightage given to Indian Contract Act and few questions you can expect from Specific Relief Act. Starting with the first question, A agrees to provide a loan to B for import of banned products. The agreement between A and B is, the correct answer here is D, illegal. An agreement which is against the provisions of law which is enforceable in India shall be considered as an illegal agreement. Therefore, for an agreement to be illegal, either the object or consideration should be illegal, which will render the agreement as an illegal agreement. Question number 2. Which of the following provisions of the Indian Contract Act deals with frustration of contract? The correct answer here is B. Section number 56 of the Indian Contract Act deals with the provisions relating to agreement to do impossible act, which is basically laying down provisions relating to doctrine of frustration, wherein it mentions about the acts which cannot be performed or the impossibility of performance of the contract. Question number 3. A is in urgent need of money for marriage of his daughter, therefore agrees to sell his house to B at a lower price than the market price. Is this agreement valid? The correct answer here is A. Yes, because A has voluntarily agreed to accept the lower price. The important element for converting an agreement into a contract is presence of consideration. However, it is not essential that the consideration should be adequate. Therefore, consideration may or may not be adequate, but it should be of some value in the eyes of law. Also, an agreement to which the consent of the promisor is freely given is not void merely on the basis that the consideration is inadequate. Question number 4. The Clayton rule is applicable to which of the following? The correct answer here is D. Appropriation of payment. In this case, also known as Clayton, it was held that the debtor can request the creditor to appropriate the amount to any of the debt in case he owes to the creditor several and distinct debts. If the creditor agrees to it, then he is bound by it. Section 59 to Section 61 of the Indian Contract Act lay down certain rules regarding the appropriation of payments. Question number 5. Claim for necessaries supplied to a person incompetent to contract is covered under. The correct answer here is B. Quasi-contractual obligation. Section 68 deals with this. Claim for necessaries supplied to person incapable of contracting or on his account. If a person incapable of entering into a contract or anyone whom he is legally bound to support is supplied by another person with necessaries suited to his condition in life, the person who has furnished such supplies is entitled to be reimbursed from the property of such incapable person. Question number 6. The famous case of Lalman Shukla versus Gauri Dutt is related to. The correct answer here is D. Knowledge of offer before acceptance. In this case, it was held that for the purpose of entering into a contract, two things are essential: to have complete knowledge of the facts of the offer or proposal, and second, acceptance of the offer. To convert a proposal into an agreement, both knowledge and assent to it must be present. However, in the given case, both were missing. As the plaintiff had no knowledge and hadn't given his approval or accepted the proposal, so there did not exist a valid contract between the two. In the case, it was held that for creating or entering into a valid contract, there must be knowledge present and assent to the offering made by the proposer. Question number 7. A painter X has entered into contract for painting picture for Y. Subsequently, X has refused. Which of the following remedy is available to Y against X? The correct answer here is A. Claim damages from X. Section 73 of the Indian Contract Act deals with it. Compensation for loss or damage caused by breach of contract. When a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby. Question number 8. When there is a breach of contract, the party which has performed a part of his obligation is entitled to recover value of what has been done by him. This remedy is known as. The correct answer here is D. Quantum merit. This is a Latin phrase which is related to Indian Contract Act, which means as much as he has earned. Further, it provides that even if there is no contract between the parties, This law implies a promise to pay a reasonable amount for the labor and material provided. Such circumstances wherein someone gets a benefit while the other party gets nothing, or the benefit or enrichment when one party receives as a result of the other party's actions. Then question number 9. The general lien is not applicable to which of the following? The correct answer here is A. Unpaid seller. This is given in section 171 of the Indian Contract Act. General lien of bankers, factors, wharfingers, attorneys and policy brokers. So it is not mention of the unpaid seller. Question number 10. A person who occupies the position of surety as well as agent is called as. The correct answer here is C. Del credere agent. This means an agent who sells products or services for another party for a fee and guarantees payment to the seller. If a del credere agent has paid the seller, the rights of the seller are assigned to that agent. Then question number 11. Specific Relief Act is applicable for enforcement of. The correct answer here is A. Civil rights of an individual. Section 4 deals with it. Specific relief to be granted only for enforcing individual civil rights and not for enforcing penal laws. Coming to question 12. Suit for recovery of possession of immovable property under section 6 of Specific Relief Act can be filed. The correct answer here is B. Within 6 months from disposition. Then coming to question number 13. With reference to the Indian Contract Act, promises which form the consideration or part of consideration for each other are called. The correct answer is D. Reciprocal promises. Section 2 interpretation clause F talks about reciprocal promises. Promises which form the consideration or part of consideration for each other are called reciprocal promises. Then question number 14. According to section 6 of the Specific Relief Act, if any person is dispossessed without his consent of immovable property otherwise than in due course of law, he or any person through whom he has been in possession or any person claiming through him may by suit recover possession thereof, notwithstanding any other title that may be set up in such suit. Section 6 talks about dispossession, not the ownership. The bold words in brackets were inserted in which year? So the amendment or the bold words when they were inserted. The correct answer here is D, in 2018 by Specific Relief Amendment Act 2018. Then coming to question number 15. According to section 22 of the Indian Contract Act, contract caused by mistake of one party as to matter of fact is. The correct answer is A, not voidable. Section 22 deals with it. Contract caused by mistake of one party as to matter of fact is not avoidable merely because it was caused under a mistake as to matter of fact. Question number 16. According to section 36 of Specific Relief Act, preventive relief is granted at the discretion of court by. The correct answer here is B, by injunction which can be temporary or perpetual. This is section number 36 of Specific Relief Act. Then question number 17. The famous case of Balfour versus Balfour is related to. The correct answer here is D. Promise between married parties is not a binding contract. The court in Balfour versus Balfour observed that agreements that are made between a husband and his wife, specifically personal family relationships to provide maintenance costs and other related capitals, are generally not categorized as contracts because, in general, the parties to the agreement do not intend to enter into an agreement that should be attending legal ends. Question number 18. With reference to Specific Relief Act, select the correct pairing of section and its title from options below. The correct answer here is D, section 14, contract not specifically enforceable. This section 15 is who may obtain specific performance, while specific performance of part of contract is given in section number 12. Then section 10 is specific performance in respect of contracts, and defenses respecting suits for relief based on contract is given in section number 9. And section 12 is specific performance of part of contract. Cases in which specific performance of contract connected with trust enforceable is given in section number 11. Question number 19. With reference to section 126 of Indian Contract Act, read the following statements and select the correct option from below. Guarantee must always be written. A guarantee may either be oral or written. The correct answer is C. 1 is not correct, 2 is correct. So guarantee can be either written or oral. Section 126 deals with contract of guarantee, surety, principal debtor and creditor. Then question number 20. According to section 4 of Specific Relief Act, specific relief can be granted only for purpose of enforcing dash and not for the purpose of enforcing dash. The correct answer here is B, individual civil rights, and not for penal laws. Coming to question number 21. With reference to Indian Contract Act, read the following statements and select the correct option from below. An agreement without consideration is always void ab initio. An agreement in writing is registered and made on account of natural love and affection, even without consideration, is valid. The correct answer here is A. 2 is correct, but 1 is not correct. Section 25 says agreement without consideration is void unless it is in writing and registered, or is a promise to compensate for something done, or is a promise to pay a debt barred by limitation law. So as option 1 says, an agreement without consideration is always void ab initio. It's not always void ab initio. It's void unless option 2. Then question 22. Section 68 to 72 of the Indian Contract Act deals with, the correct answer here is C, certain relations resembling those created by contract. This is chapter number 5 of certain relations resembling those created by contract, where section 68 talks about claim for necessaries supplied to person incapable of contracting or on his account. 69 talks about reimbursement of person paying money due to another in payment of which he is entrusted. Section 70 is obligation of person enjoying benefit of non-gratuitous act. Section 71 is responsibility of finder of goods. 72 is liability of person to whom money is paid or thing delivered by mistake or under coercion. Then question number 23. Under which section of Specific Relief Act the court has been empowered to engage expert in any suit? The correct answer here is D, section 14A, power of court to engage experts. Then question number 24. Section 37 of the Indian Contract Act deals with, the correct answer here is B, obligation of parties. Then question number 25. Section 211 to section 221 of the Indian Contract Act deals with, the correct answer here is B, agent's duties to principal. Chapter 10 talks about agency. Section 211 talks about agent's duty in conducting principal's business. And you can read the headings of various sections here. Question 26. In which of the following cases the Supreme Court of India struck down a clause in service agreement whereby service of a permanent employee could be terminated by giving 3 months notice as unreasonable and opposed to public policy? The correct answer here is B, Central Inland Water Transport Corporation Limited versus Brojunath. In this case, the Supreme Court struck down a clause in service agreement whereby the service of a permanent employee could be terminated by giving him 3 months notice or 3 months salary. It was held that such clause was unreasonable and against public policy and void under section 23 of the Indian Contract Act. Also, under section 24, if any part of a single consideration for one or more objects or any one or any part of any one of the several considerations for a single object is unlawful, the agreement is void. So these were all the questions that have come from Indian Contract Act and Specific Relief Act. I hope you get the idea. Many questions are based on section numbers. Either you are asked the section number or you are asked the heading, the title of this section or the chapter. So be thorough with the index of laws for Coal India exam. If you are looking for preparation material for Coal India exam, you can check out our online course. In this, you will get video lessons, study notes, live classes, difficulty-based chapter tests and section tests, full-length practice tests, and many practice questions. That's all for now. Enroll with iExamB and make your preparation 50% faster. Thank you so much for watching this video. Subscribe to our channel. Stay tuned.